Welcome to the program. I'm Marty Schenkman, and I'm joined by two brilliant and illustrious colleagues, Mary Vandeneck from Omaha, Nebraska, and Jonathan Blattmacher from New York. And we're going to discuss a really significant, I think it's significant. I don't know if my colleagues will agree with that, but I think a very significant case that I think has some important implications to planning generally. We'll talk about that at the end. And some really important issues that you may need to start addressing with all of your clients that have buy-sell agreements, and we're going to talk about that. And our goal is going to be not just to parse through the Connelly case, but to leave you with practical suggestions of actionable items that you can use in your practice. Before we get started, a few very quick housekeeping things. The webinar is recorded, and after the program, within a reasonable amount of time, the webinar and the materials we posted to the Schenkman Law website, the Peak website, and the ILS website. And we don't give CPE or CLE, but you should receive a certificate of attendance automatically from the system. If there's any issues with that certificate, we can't modify it. It's all done automatically. Our first sponsor is ILS. And Vanessa, maybe you can say a few words for us. Oops.
I'm glad to. My name is Vanessa Knega. I'm the CEO of Interactive.
Vanessa, you're muted.
Oh, no, I'm not. You can't hear me?
Take it back.
I can hear you. Okay. Sorry about that. Hi, everyone. I'm Vanessa Knega. I'm the CEO of Interactive Legal. We provide automated drafting solutions, education, and other resources for estate planning and elder law attorneys. If you're not familiar with us, please check out our website at interactivelegal.com. You'll find a lot of good resources, including some that are available to the public, such as this webinar and others like it. And we're always really grateful to Marty, Jonathan, and in this case, especially grateful to Mary for presenting on current topics and getting information out there pretty much in real time as it comes down. So if you have any inquiries for us, please feel free to email us at the sales email address on your screen, and I will turn it back over to Marty.
And our second sponsor is Peak Trust Company. I'm trying to keep track of all the jurisdictions you're in now. You may be able to tell everyone because it keeps growing.
It does. Excuse me. Welcome, everyone. Thank you for attending today's webinar. My name is Nicole King. I'm a fiduciary officer here at Peak Trust, and we're pleased to honored to be a sponsor of today's presentation. Peak Trust is a full service trust company. And we specialize in the administration of trusts in Alaska, Nevada, and Delaware law. We provide a very, very highly customized process tailored to your client's needs. So I invite you to visit our website at peaktrust.com. And if you should have any questions, please feel free to reach out to me or any member of our team.
And by the way, just as a comment, since Nicole won't be here to hear it later, at the end, Mary and Jonathan are going to give me a couple of minutes to talk about some of the broader implications of the Connelly case, which has kind of created a trend with Smaldino, Levine, Sorensen, and Connelly with some of the same messages. And one of those take-home messages is use an institutional independent trustee when you can. It's going to enhance the likelihood of planning succeeding. So that's a unbiased plug for Peak. So let's get started. Thank you, Nicole, and thank you, Vanessa. And let's jump into it. And what we're going to do is we're going to have Mary lead the charge. I'm going to advance the slides as best as I can. And if I don't do it correctly, Mary will yell at me. She actually has an electronic thing that will send an electronic shock and jolt me, so I will have to pay attention and change slides properly. Mary's going to lead the charge, and Jonathan and I will comment as we go. So Mary, let's take it away. We have a new case that's got some important points.
So Connelly v. United States, and it's out of the 8th Circuit, and I'm in that jurisdiction. So it really impacts me in my practice in terms of how to advise clients on business buy-sell agreements. We kind of have a summary of the what to do now, and we're going to circle back at the end with some practical pointers, because even Jonathan, Marty, and I have had some animated conversations in the last several days about whether this case is right, wrong, or, you know, a variety of issues related to it. And so at the end of the day, it's kind of like, what should we really do now? So I think, you know, thing one is really talking to clients about the fact that this case is out there. So whether or not you agree with what the court said, or whether or not you're in the ACE circuit, is you've got to consider this, go forward in your buy-sell agreements. And actually, to the extent you have any buy-sell agreements out there, take a look at them and rethink them, make sure that they line up with this case, or at least that you've thought about. To the extent it doesn't, it's a conscious decision. So take a look at the language, and especially in the redemption buyout agreements. So this was a redemption buyout that was impacted, said life insurance is included in the value of the company, and that's what's causing the big to-do. Look at this as an opportunity to talk to clients about the importance of paying attention. You know, sometimes we put a document in place, we create a strategy. In the absence of follow-up, and I think, you know, Marty will elaborate on that, but it's really important to know what you put together, to follow through, make sure you're keeping up, reviewing, documenting it. Just all really matters. In looking
Can
at,
I got to
go ahead.
interject a point because it's so important. If you're an attorney, you want to follow up with clients that have these agreements in place, and we're going to talk about it, and Mary has sample language, all sorts of stuff. But if you're an accountant, if you're a financial advisor, an insurance consultant, you have to help get the clients to go back to their attorneys to address some of these issues. So you have an important and critical role as well. This is for everybody in all disciplines, because clients, like in this case we'll illustrate, and we'll all talk about it, they just didn't pay attention to the formalities. So we all need to get clients educated to deal with that. That's just my personal thing. I'm just frustrated trying to get clients to do it. So my appeal to all.
Yeah, and I think what we can do is we can educate our clients when we're working on transactions, and we can follow up with them, explain the ramifications, and, you know, but this case is really a call to action on that issue, and we've had a variety of those cases, as you're going to talk about a little further. The other thing is, this case referred to, one of the mechanisms was a certificate of stated value, and that's a fairly common strategy that's used, where clients will say, a company, the owners will say, we're going to get together once a year or every 18 months, and we're just going to decide what the value of the company is. This case says, if you're using that method, which I use that a fair amount, if you're doing that, then what you're going to want to do is have some support for what that value is. If you want that respected for, you know, there's a contractual issue, is this contract binding between the parties? And in the event of death, does that establish the estate tax value for purposes of the estate? And what you don't probably want is to have somebody pass away and they get a smaller amount than what the company is going to be valued at, and they pay potentially estate tax on income they never got. So that's part of why this is really important.
Mary,
Go ahead, Jonathan.
let me interrupt here because I've had this happen. Let's say they have agreed on a value of $5 million and the IRS establishes, and the courts agree, that it's worth $10 million. Well, they're going to have to pay estate tax on $10 million. But who pays the estate tax on the extra $5 million of value? If you have a will which says pay all taxes due by reason of my death from my own estate, wow, the estate may be wiped out on account of that. Now, there's one case in New York that suggests that actually it is the person who buys the property who's liable for that extra estate tax. But there are other cases which say no, that the estate has to bear that extra estate tax. That's something that should go in the buy-sell agreement. Now, I've had people say to me, oh, Jonathan, don't do that because the IRS will see that maybe you didn't really believe it. No, it's not a matter that we don't believe it. It's just we have to acknowledge that the IRS and a court may say it's different than the value agreed upon by the parties. And if that happens, even though the parties believe they have a binding agreement on value, or they've had an appraiser who comes up with a correct value, who pays that tax? It's critically important.
That's a
So
great idea. Great idea, because the carnage that will happen with the wrong tax allocation. Yes, great idea.
I can't put enough, emphasis behind what you just said. I think that's like, I should have had a slide in here that put that in big bold letters. I am going to just talk briefly about the facts in the case, just so there's the backdrop for this webinar in terms of the case for anybody who hasn't read it. It's a typical closely held business owned by two brothers. So Michael and Thomas, and Michael had the majority interest with 77.18. And they did enter into a stock purchase agreement, and the purpose of that is to kind of control the ownership. A lot of times survivor doesn't want to have a partner that's one of the beneficiaries that they don't know or don't want to have involved in the business. So this is really common. In this case, the corporation, so what the agreement said is, okay, look, there's two of us, either one of us can buy the other out upon death. If we don't exercise that ability to buy the other out, then the corporation, the company has a mandatory obligation to redeem the other. So in this case, Michael dies, and Thomas decides, the one brother decides not to buy the other brother out, so it's a redemption. There was $3.5 million of insurance. It was agreed on that the base value of the business was approximately $3.3 million for getting the insurance. So the insurance then comes and pays in. The stock purchase agreement said, okay, well,
It's paid into the corporation, not to the surviving shareholder.
yes, good point. So the corporation owned and was the beneficiary of this life insurance policy. So the stock purchase agreement had two mechanisms for redemption of the shares. One was provided for a certificate of agreed value. So they were supposed to, at the end of each year, sit down and agree on a price. Well, the two brothers never did that, never used a certificate of agreed value. The second was that they would have an appraisal. And there were some specific, if you go back and look at the tax court opinion about the timing and how the appraisal would be done, fairly specific details in the agreement on what that appraisal requirement would look like. Well, Michael died in 2013. There were no appraisals obtained related to the death of Michael. Thomas, of course, was the surviving shareholder of the company. Thomas was also the executor of Michael's estate. So he entered into an agreement with himself. And I think, some commentators and some are saying, well, this is just a bad facts case. But I don't personally think you can write this off to bad facts. I think the ultimate decision is right given the facts. Whether it would have been different in another case, I don't know. But anyway, Michael entered into an agreement with himself and said, hey, we're going to pay the estate $3 million.
Mary, let me ask a question. Since the surviving shareholder was the executor as well as the surviving shareholder, and
the brother,
a brother, is he in a position of conflict of interest so that he shouldn't be doing this? He shouldn't be involved? I mean, he's an executor. He's got a fiduciary duty. Normally, if you have a fiduciary duty, you're not supposed to self-deal. The case doesn't really tell us whether or not there is something so bad going on, although you've got to remember it's extremely common. And again, I would recommend that if you are going to have the other shareholder or shareholders be the fiduciaries who have to carry out the agreement on behalf of the estate and the family of the deceased shareholder, you need to put something in the documents where the deceased shareholder's will or revocable trust acknowledges that there's a conflict, but nonetheless wants that person to serve and to carry out what's supposed to be in the buy-sell agreement. Normally, if you have that in the instrument, the courts will respect it. There was nothing to indicate that they had that in any of the instruments, and I think therefore someone could come in and complain that the surviving shareholder, brother / executor, was guilty of an act of self-dealing.
And again,
Just a couple of
Go
quick
ahead,
things to
Marty.
emphasize what you and Jonathan said. Jonathan's correct, and you can try to resolve the issue by having the conflict acknowledged and waived. The optics are still bad. It would be far preferable, in my opinion, and I think it would have changed how the court was looking at this. I don't know that it would change the result, but I think it would have been far better had, number one, Mary talked about how they never signed a certificate of agreed value that they had talked about and agreed to. They never got the appraisals, and then you had this conflict of interest all across the board, the brother, surviving shareholder, and the executor. The surviving brother should have resigned and had an independent person named as executor. It would have looked a lot better. The two brothers, when they were alive, should have carried out and adhered to the provisions of their agreement. I don't know that either of those facts would have changed the result in the case, because I think the court's views on the includability of insurance, which Mary's going to get to, may be the same regardless, but it's not the way to do it. And just a comment, Mary made a comment that I often hear court colleagues dismiss particular cases as being, oh, that's a bad fact case. Whether something's a good case or a bad fact case or a fair fact or a good fact case, there's always lessons to learn from every case. And that's why we're taking the time to parse through Connelly and try to share with you some of the lessons we think you can glean from it. So regardless of whether you think it's a bad fact case, there's very important lessons to learn. Mary?
So, yep. So just emphasis on that and covering in the agreement, making sure, like, I include in any of my testamentary documents a specific statement. If somebody has a position of conflict of interest, as the executor does, do they have the right to engage in a transaction? So that's super important. Well, the estate tax return was filed in this case, and the estate tax return valued Michael's shares at the $3 million that Thomas had agreed to pay. And the son was involved a little bit, so at least there was somebody else. The IRS audited the estate tax return. IRS concluded the shares were undervalued. And what the IRS said is life insurance proceeds that were paid to the company were required to be taken into account when valuing the company. So IRS issued notice of deficiency, estate paid the deficiency, filed a refund suit. Tax court ruled in favor of the IRS, went to the 8th Circuit. So stock purchase agreement, again, those are used. So let's talk a little bit about what the court really looked at. And I like the way the tax court laid out the analysis of 2703 A and B, but 2703 basically says, you know, these are valuation provisions. And it says, okay, we're not going to look at the value if we have various restrictions with respect to a property, and a stock purchase agreement typically fits into the category. But 230B says this shall not apply if it's a bona fide business arrangement, not a device to transfer such property to members of the decedent's family for less than full and adequate consideration, and its terms are comparable and similar arrangements entered into by persons in an arm's length transaction. Important thing about 2703B, this is you have to meet all three of the tests in 230B. Tax court went through each of these provisions one at a time and concluded it is a bona fide business arrangement, it's not a device to transfer, and where it took issue is terms are comparable to similar arrangements entered into by persons in an arm's length transaction.
Mary, let me begin by saying that people want to say that the buy-sell price that the partners or the shareholders have agreed to will fix estate tax value. But even before Section 2703 was adopted, as it was in October of 1990, it didn't automatically mean that it would be respected. For example, as a general rule, it had to be binding during lifetime as well as death. So if the three of us, Mary, Marty, and I, could go ahead and enter into an agreement, but any of us could sell our stock or transfer our stock without regard to the agreed upon procedure, it's going to not be even considered a death. So you've got to make sure that you meet all the criteria, which is set forth in the regulation in the regular case, And then you have to say, well, okay, if we meet those and we think we do have something which sets the price, and by the way, it has to be a fixed or determinable pursuant to a formula price. It can't be, you know, whatever we think we want. Then you're going to have to go ahead. Even if you meet that, then you're going to have to go ahead and run the gauntlet of 2703. Now, if you have arm's length people, not brothers as we had here, or mother or daughter, or father or son, maybe there's a better chance that the court or the IRS would accept the value which has been agreed to. But even in those cases, you can't be sure. Remember, and I hope no one will call the IRS and tell them that I said this, but I think the IRS is only in it for the money. And whenever you give them, it's true, Mary, I know you think
Mary,
I'm a
cover
bad,
your ears.
yeah, I
Cover
know,
your
you
ears.
think I'm a bad American for saying that. But if the IRS sees an opportunity to come in and grab tax dollars because you didn't dot every I and cross every T, you're going to be in a world of hurt, and your clients will be unhappy, and there'll be a lot of expense paid. So as Mary has been emphasizing, this is something that has to happen during lifetime. And I think Mary is absolutely right, you know, having the thing updated all the time. But if you never get it updated, that's going to be a bad fact. So the lawyer has to really goose the clients every year to say, hey, we got to have a meeting and set this price, or at least have a record in a meeting that we met and we didn't think the price should change.
Um, since this is being recorded, I don't know that I'm going to agree that it's the responsibility of the attorney to goose the client every year. I do believe that most of us, when we represent a client, tell them you should update this. Hey, come back periodically, come back every year for minutes, for review of general business matters and estate planning, and to update a certificate of value. I believe that most people likely tell their clients that, and the other advisors should also be involved in that, the financial advisor, the accountant as well, because we all have a role to play in this. But I wouldn't want to have something recorded that says we have a responsibility to goose them. The problem I find, and Mary seems much more successful at this than I do, I find it's very difficult to get people to come back even every couple of years, yet alone every year, to address the wide range of things they need. And I think that's part of the challenge. And that's something that we all struggle with as lawyers and professionals, is to get our clients to come back. And we all know why that is, Jonathan. What do we do that makes them not want to come back? Because we're a lot of fun.
We charge them money. But
Yes.
again, in fact, Marty is absolutely right. You don't want to just say, I've got the responsibility. I think what you can say, if you want us to, we will goose you every year. We'll send out a letter saying that you need to get together on that. And maybe that's the best thing to happen. Then if the clients ignore it, they ignore it. But your letter can say, look, we have told you about this. You agreed that we should goose you every once in a while. So you could consider meeting and updating things.
So, and I think one of the things, Marty, when you and I were talking about it, and I said, well, I'm just a royal pain in the pazoo about it. And you said, well, I am too. But one of the things I do, instead of just sending a reminder letter, is when we actually put the agreement in place, I just schedule a meeting a year out. And if it has to be rescheduled, then who cares? But a lot of times by putting that meeting on the calendar, then sometimes they get the follow through. And if it gets canceled, a lot of times we'll reschedule as opposed to not getting it done. And that's just one of the ways that I approach that, because I think it is kind of important. But I also agree that at the end of the day, if we've let clients know and they choose not to act, it's their responsibility in terms of it. So that's partly the letter that we send out as we do the project, reminding them of the obligations and the timing of them and the ramifications of not complying. So that's kind of a different thing. Well, I'm going to go back to the court really took argument. And the first time I read this case, I was like, how can you say that the fact of, an appraisal is not appropriate and you, the court, are deciding to add the life insurance proceeds to value? And I just want to remind, I've said it and Marty said it, Jonathan's repeated it a couple times, that the key here is, what are the parties contractually agreeing to as far as the price? And then does the IRS have to respect that when it comes to estate tax valuation? And if there's a difference, I think Jonathan did a great job with that earlier on, so I'm not going to reiterate it, but what happens? And you probably want those two things to come together. What the court focused on is says, well, we're not going to, there's no fixed and determinable price. I could potentially take an issue with that with respect to the appraisal, but the fact is they didn't go get one. So would it have been different if they did? But I think it's the vicinity of appraisers to decide values of the company versus the court. And there's several cases out there that say that. But they didn't tell us, and the court specifically said, well, we're not going to tell you exactly what an appropriate formula is. So that's kind of out there. What they went to was the third prong of 2703B and said, this does not meet the third prong of 230B because at the end of the day, if you take the base value of the company and we add the insurance value to that, so we'll add that $3.5 million, then a willing buyer is going to pay the entire value. And I think it was the 3.3 plus the 3.5, so $6.8 million. And their point was, if an outside buyer, again, forget that this is two brothers that are involved, comes in and says, okay, I'm going to put $6.8 million. I'm happy to buy that because that's what this company is worth. And then I own the redemption obligation. So that was part of the position of the estate, was that the proceeds of the life insurance were offset by an IRS, by the obligation to redeem. And there's been a whole lot of discussion about the obligation to redeem versus the redemption itself, which I'm not going to go into unless Marty or Jonathan wants to jump in on that. But at the end of the day, the court said, we've got 6.8 million, buyer buys it. He can extinguish that redemption obligation because now it's to himself. So he has 6.8 million. Or he can buy out the redemption, but this same buyer still has 6.8 million of dollars. It's just a matter of which pocket it is in. So the court also
That's part of the opinion that I just struggle with. If an unrelated person came and evaluated this company and wrote out a check for the 6.8, they know in writing out the check they still have to buy out the estate of the deceased brother. That's the piece I don't understand. And that's what the court was pretty insistent on, is that it's the gross value. It's not reduced by the buyout obligation. I don't know if either of you may want to comment on that, because I think other people may find that quirky or difficult to understand.
Let me tell you, there have been a lot of comments back and forth as to whether or not the court was right, basically in adding the insurance proceeds to value. And let me tell you how I've analyzed this. Let's say Marty and I have a business and he and I agree, everybody in the world agrees that today it's worth $4 million. And Marty is going to buy me out for half when I die, which means I would be paid $2 million. And I don't think we'd say, well, the value of the company is not 4 million, it's 4 million minus the redemption obligation to buy me out. And when you do the math, it's a so-called interrelated computation. It means the company is worth 2.67 million and I get 1.3 million. And in fact, if you take 4 million and you subtract out 1.3, you're left with 2.6 essentially, and I get half of that. That's just the math, the way it works. But in fact, we've all agreed it's worth $4 million. So my estate should get $2 million. I don't think anybody would disagree with that. Now, if there is a policy of insurance payable upon my death to the company, now it's going to have a value of $6 million. So I think then my family gets half of that value. It gets $3 million, not $2 million. You might say, well, but that's insurance. It doesn't matter. I mean, let's suppose, Marty, you and I have this business and you and I agree that rather than buying insurance, which beyond the age of 80 is probably not a very good investment, we're going to buy some other assets. So you and I decide we're going to buy a piece of vacant land. And each year, instead of paying a $100,000 premium, we pay off the debt on this $2 million piece of land. So, and it's paid off when I die. So the company, instead of being worth 4 million, which it's worth as a going concern, is now worth 6 million. There's no insurance involved. And I think I get 3 million. I think that's what the court in Connelly was saying. And I think it would be very, very difficult to argue against it, although The Blount case, which Mary has cited at the end of this particular slide up there, they took it out. And of course, the Eighth Circuit, which Mary is in, which just decided Connelly, said, we think that the Eighth Circuit is wrong. And I think the Eighth Circuit is wrong. But maybe my opinion and Marty's opinion and Mary's opinion doesn't matter. The critical thing to do is to have a buy-sell agreement, which will take whatever you want into account, will do it. But I think if you have, like if Marty and I do this and we buy this vacant piece of land with our extra money each year, I think if we put in that we're not going to get paid when we die for the extra $2 million, which we've taken out of our own earnings, I paid half of that, I'd be making a very bad business deal. I'm not going to tell you people don't do that, especially when it comes to insurance, which is not usually very understood. But I think that you'd have to consider that piece of property which we're buying instead of insurance to be something that would be considered in determining fair market value.
Let me make two very quick points. I think it's vital, and Mary said it and Jonathan said it, so I'm going to just reiterate it. What is in the agreement? I'm concerned that many clients don't really understand what's in the agreement. I think many clients in their perception of this transaction feel that using Jonathan's example, $4 million company, me and Jonathan are partners. He dies, there's a $2 million payout to him that's insurance funded. I think most clients assume that the insurance is not part of any of these equations. Well, the court Connelly said, listen, it's part of the value for tax purposes. Now, the economics of what we agree to, we can agree to anything we want. That may not affect the tax consequences. I think it's critical that clients first understand what's in their existing agreement. And second, that agreement be very explicit as to what's happening with insurance or any other way. And Jonathan pointed out what I think is typically called a sinking fund. There's lots of ways you can fund a buyout or just use debt financing when the event happens. Clients need to understand what's there in the agreement, needs to be specific. I'm going to make a very quick comment, and I don't want to belabor it because there's so much more for Mary to cover, but I think one of the reasons people perceive insurance different is in many, not all, but in many cases, the insurance used is inexpensive term insurance. And when somebody is paying a very modest amount of an insurance premium, they don't view it in the same way they view the asset that Jonathan very well illustrated, like a piece of raw land, like a sinking fund. So that may be part of why clients perceive this differently. So I think it's critical, as Mary said, that we can convey to clients what it is and we confirm what they really want and that it's expressed in the agreement. Mary?
And so I just want to remind, and I think we have a comment later in the slides, that when you're doing a buy-sell agreement, we're looking at all of the triggering events. And it might be retirement, it might be disability, it might be death. And when you're looking at that value, so that discussion we've had about I'm entering into an agreement about the value, if my business partner goes down the street to start a competing law firm, I don't want to pay him I want to pay him as little as possible and give him as little help starting my competitor as possible. So in working through this, death is only one of the triggering events. And so when we're talking about the Connelly case, clearly we're talking about death, how we're valuing it. And I just want to do a reminder that in discussing this with clients, we want to go through all the triggering events, consider their objectives with respect to each, give some thought to what's most important. And then I'm big on doing the math, and I've done some of that later in the slides showing the different economics. And so I'll come back to that, but there's a lot of discussion about only use a cross purchase now, only use an insurance LLC, never do a redemption. It's really it depends, and there's blended options. But I think it's important to keep in mind that a buy sell may cover more than death. And so you have to kind of think through, what are we trying to do? What are we trying to cover? And should the valuation be different for different circumstances? And I'm going to just buzz, I'm actually on slide 17, where the court talked about that we didn't have a fixed or determinable price in Connelly. Didn't give us a lot of guidance on what that would look like. Again, I take a little issue with sort of minimizing the role of an appraiser, because that's actually pretty well accepted by the IRS for most purposes with respect to estate taxes. And I'm going to just roll to slide 20, Marty, which just talks about the non-operating assets. So the court said, well, life insurance, that comes in, or if you look at the sinking fund, which is classified differently, various things, at the end of the day, that money is in the company and we have to look at it in determining the price. So the other thing, so I talked about the willing buyer, which I've kind of shared on that, but the value of the shares, which was an interesting calculation that the court did, and it's on slide 23, is that the court said, hey, if you look at this value of the company before we pay out these insurance, if we do this, the value is $7,720 per share. Afterwards, the shares are $33,800. All this is really saying is that after we pay out the redemption, so you redeem the shares of the deceased, there's less total shares, so they're worth more. But when you do the math, the way that the court did, it said at the end of the day, he's paid out the redemption obligation and he has a company worth the entirety instead of something less. And that's a little bit of the court's objection. Any comments on that before we move on from the facts of the case?
I'm going to just say that your comment that it depends applies here too, because the surviving shareholder may in fact have a company that theoretically is worth a lot more per share, and they may own 100% of the pie now. But is that pie really viable when a major and perhaps key shareholder has died in a closely held business? And that depends. Sometimes the surviving the family of the deceased shareholder that got a lesser amount based on an insurance buyout has cash and is done, and the survivor has to fend with a company that may not be as strong, may have lost a key person whose reputation helped build the company. It may have debt from how they paid out the deceased shareholder's estate. So it really depends. I don't know that the court's assumptions here are necessarily correct.
They're slightly overly broad, right? In the sense that you're exactly right. If you've lost a key person, which you could argue that, well, you should have had key person life insurance rather than insurance to fund a redemption. But you have lost somebody that's valuable to the company. Is it worth as much? But that'd be a factor to consider in a formula. But I guess I would also point out that when the court says the valuation is something more, and we now have insufficient life insurance to fund the redemption, then to the extent that that redemption is paid out of the company, that's a non-deductible expense. That when I look at the economics, and I did some examples of the economics that I kept simple and didn't put all of those factors in because it would have been 100 slides to do it. But those are the type of things you have to consider. But that's why I'm about what are the triggering events and what are the economics and how do you want it to work in each of these situations? Do either of you want to comment on the Blount case? I'm not sure we really have time to spend too much time on the 11th Circuit case. No?
Let's just, Jonathan, do you feel that there's a conflict between these that may have to be resolved?
Well, I do think they are inconsistent, Marty. Blount basically held we would reduce the value of the company by the redemption obligation. Again, as you know, and I think Mary agrees with me, I think that that's wrong. But that's what Blount said. I think it is a distinction, and whether or not the Blount estate, which I think is the Connelly estate could get a writ for certiorari to the Supreme Court, because one of the cases where the Supreme Court will take a case on appeal is where you have a conflict in the circuits. And I think there is an outside chance the court would agree there is a conflict. Of course, in today's terms, the amount involved ain't that much money. But I don't think they're going to try to appeal to the Supreme Court on this, get a writ of certiorari on it. But maybe it'll happen. But I do think that they are inconsistent.
Just more to caution clients about.
Mary, do you think they are?
I think they're inconsistent. And, whether or not we'll get a resolution on that, I don't know. I think the answer for practitioners is to think through their agreements and what's included in them and make sure whether they're in a Blount jurisdiction or in a Connelly jurisdiction that you've got 2703 addressed.
Yeah, let me mention something here. If you really thought you were going to wind up with this case, but not in either the Eighth Circuit or the 11th Circuit, and let's say you say, I really want to be in the 11th Circuit because that's where Blount was decided, and that's where I want to be. How can I get there? Well, the way you can get there, and this is a good thing to know, you make sure you have an executor or an administrator CTA who's in that particular circuit. That provides the ground for the appeal. Now, strange it might seem. Wait a second, Jonathan, isn't it the residency of the decedent? No, it is not. The taxpayer is going to be the executor, and I've used this to get into a circuit which I wanted to because the law was more favorable there. So if you do come up with this is something where you have the ability by getting someone appointed as an executor or administrator CTA early on to get the circuit you want.
So let's
Mary,
skip
what's
to.
next?
I think that's a great thought process, actually. I'm going to go to a point that, I'm the do the math obsessed, and I'm going to use Jonathan's example to go here in terms of talking a little bit about what I think we really need to think about in our agreements. Because I think if you look at the Connelly case, we have different results now in terms of the economics in certain situations between a redemption and a cross purchase. And I've heard some commentators say, oh, well, that's why you only do the cross purchase. And I'm like, well, I don't know. If you think about it and you're the estate of the deceased, I'm not sure you're going to agree with that. So I'm going to use Jonathan's example of the $4 million business. Now, let's assume that we have an agreement that sometimes an agreement will say we're going to pay somebody X amount pursuant to the certificate of agreed value. But let's just say that we have that business. Jonathan and Marty own it 50-50. It's worth $4 million. And they fund a buy sell with that $2 million of life insurance. So under the Connelly case, in a redemption scenario, so now we have that $2 million comes into the company, and that's a non-operating asset. So we say, okay, this business is worth $4 million plus the $2 million of the life insurance proceeds. So now we have a value of $6 million. I'm not going to kill either of you off. So I'm just going to say, whichever one of you died, your estate, well, I don't want either of you going anywhere soon. So anyway, whichever of you is not here, your estate is going to get $3 million. And then the business that you have is going to be worth $3 million. So you each have $3 million. If instead we have a cross purchase, and so the survivor gets paid in that case in the cross purchase agreement, the survivor would have been in the situation where he or she owns the life insurance policy on the deceased and is the beneficiary. So survivor gets the $2 million, pays $2 million to the estate. So now the economics of the cross purchase are the estate gets $2 million. The survivor has a business worth $4 million. And so my question is that what you were really thinking that was going to happen when you funded the buy sell? If the answer to that is yes, then the cross purchase is great. If not, you have to reconsider it. I'm just pointing that out. There's other factors in difference of the economics, which are also in the cross purchase. You basically get a new basis, and the redemption, you're using non-deductible funds to the extent you're not funded by life insurance. All of those things have to be considered. So just don't do the math and say, hey, we're funding with $2 million on this without thinking about the consequences of it, and design intentionally when you're doing the agreements.
I think a lot of these are not designed intentionally as you're recommending, and I think that's obviously the the right thing to do. And I think some of the reason they're not designed intentionally is because the insurance in many cases, especially when it's young owners, is very inexpensive, and they simply structure a deal because it's cheap to buy some term insurance. The problems with that, if it's not structured right, what are you getting? But secondly, as the shareholders get older, what are they really going to be able to do with the buy sell when it becomes unaffordable to keep renewing that insurance, or the cost becomes very expensive? So that's not always an answer. Question for you, Mary. If I structured a deal with Jonathan and we expressly said in our redemption agreement, thou shalt not include the insurance in the value of what you pay the deceased shareholder's estate. So in that case, the company would get 2 million. It would use the 2 million to pay off the deceased shareholder's estate. But if we're related, and I don't know that you knew Jonathan and I are related, but we're related. Is that why we're subject to 2703? But if we're related and that kicks in, and maybe it doesn't even need to be related because as Jonathan said, it's still a fair market value analysis. From an estate tax perspective, the deceased shareholder's estate, even though they got paid 2, might that not be a $3 million estate inclusion? So it doesn't have to be that the value, including the insurance, is what's paid. It's what the agreement says.
Well,
Correct. Go ahead,
the,
Jonathan.
the existence of the agreement certainly will be taken into account by the court. I mean, the IRS will typically argue if it can get more money, and remember, you can quote me, the IRS is only in it for the money. If they see that they can get a higher estate tax value, they're going to go for that. I mean, today, again, if you've got under $12 million and you haven't used your exemption, you don't care. But, you know, we're talking about probably companies worth an awful lot of money. So you have to really pay attention to that. I mean, that's something that's there. But remember, your agreement is not necessarily going to bind the Internal Revenue Service, even if Section 2703 does not directly apply because it's not with a family. 2703 can apply even if it's not a family deal. If you're very sloppy and you do the wrong thing and it just doesn't make sense, or for example, Marty likes me so much, he says, I don't care that Jonathan can buy me out on the cheap, or I say, I don't care that Marty can buy me out on the cheap. You know, we're pals, we're buddies. Well, I don't think you're going to have something that's going to be respected because it's going to flunk under 2703. First, I want to emphasize, you've got to run through the requirements under 2031, the regulations under 2031, which requires a fixed and determinable price as well as other factors. Even if you can run that gauntlet and not be crushed by something, then you can take a look at 2703 and see whether you're going to still have that agreement be considered. It doesn't say it fixes the price, it's just to be considered. And I've had appraisals even in the tax court where the difference between my value on behalf of the taxpayer and the IRS's value was 30-1.
Did you win or lose on that?
You know, the judge split the difference. I was so
Oh,
angry.
that's a bigger ouch.
Yeah, it was the estate of Josephine Thompson. And after the trial, the judge called us in and he said, I don't want to have to decide this case. I insist you settle it. But the IRS wouldn't settle it. So I think the decision is a horrible decision, just horrible. He ignored our expert witnesses, but it was very, very complicated. It was a complicated business, which was being destroyed, I felt, by the internet. But the judge said, well, I'm not so sure if the internet is going to have that big an impact, Jonathan. Duh. But you know, it's one of those things where, you know, I was disappointed in the result. I felt it was much closer to what we said as opposed to what the government's experts said.
And that's one of the challenges, even with appraisals. But I'll still, and I'm actually kind of gone to slide 44. Sorry to blow past where you're at, Marty. But just going to kind of say that what I think, and partly with your question and comment, I'm going to recouch it as you may or may not have meant it. But does this case say you have to take the proceeds, you know, the face value of the life insurance, and if you're designing a formula in a buy-sell agreement, do you have to say, oh, add the entire value of the face value of life insurance proceeds. I don't think that that's the answer. I do think you have to at least have life insurance considered in your formula. And in the past, my agreements actually said if I was doing a redemption, I would include language that said any life insurance paid in upon the death of an owner shall be disregarded. I'm sitting there at this point now. Once upon a time, we used a lot of whole life and other products. You said pretty much you see term. I do see a variety of products. So I would include like the interpolated terminal reserve or the life insurance value. But I'm looking at that language, and I can tell you I don't have an exact answer yet, but I don't feel like I have to add the insurance. I think I have to consider it in my formula design. And so this is to the extent, I do a lot of certificate of agreed values, and I've shared with you the approach that I started, which was in one case where we had a client enter into kind of an interesting buy sell, but what we did is to initially value the company, we hired an appraiser. Rather than having a new appraisal every year, we had that appraiser also provide us a methodology for the appraisal. And so we would use that methodology each year to determine the value of the company. And if there were factors, in this case, say, what are the correct numbers? What's the correct factor? What's being considered? What's going on with the economy? We would create documentation on that, have a meeting with a set of minutes that documents, hey, we use this formula and these are the adjustments, these are what we considered, have been fairly successful using that approach. So I think if you're going to use a certificate of agreed value, you probably just don't pull the number out of the air. You need something to back it up. You can also put a specific valuation formula in your agreement. And if you put the formula, which I often use a formula, one of the common ones, I use is adjusted book value. That's not going to be appropriate for every business by, any means. So, but it's one that for some companies will be appropriate. And in that adjusted book value, and I've put some language in here and I've added some that I'm going to continue to evolve that says to the extent there's a redemption and an insurance, if the value of the company, the payout's going to exceed the life insurance, then it's appropriate to consider the tax cost to the company and the valuation. So trying to consider all the factors that might affect, so if you do use the redemption approach. One of my other approaches that I like to use, and I've put some language in the PowerPoint on this, is I use a combination agreement. So I will have an agreement that says we'll do a cross purchase to the extent of insurance, and then have the company redeem any remaining value from the shareholders.
Mary, let me make a comment back to something you said before, that if you have a cross purchase agreement, company's worth $4 million, Marty gets $2 million of insurance when I die, and he uses that to buy me out. Now he has a $4 million business, but he's paid for that insurance as a practical matter. It's like if he just saved money on the side, and when I die, he uses that money to buy me out in a cross purchase. I must say that other than the fact that it becomes unwieldy if you have a lot of shareholders or partners, and there are mechanisms like using an independent LLC among the parties, I really prefer the cross purchase rather than the redemption agreement. Maybe that's just me, but that's what I've typically used in my practice when I was doing these things.
I use a lot of cross purchase, and you get into the complications of multiple shareholders. I do like the insurance LLC, which we've covered. And I think, in chatting with you about this presentation, one of the things when you use the cross purchase and the insurance LLC, you have a lot of strategies to use to take the proceeds outside the estate, which is beyond the scope of what we're talking about today. But that's one of the reasons that I do use the cross purchase often. The redemption comes into play as well, and I've used that combination approach. Just wanted to share that. But I agree that generally the cross purchase does make a lot of sense. But after this case, I am going to have conversations about that difference in economics, which I think you could also account for in your cross purchase buy sell as well. And as you mentioned, well, Marty paid the premiums, you also owned a policy on him and were paying the premiums. So both of you are out of pocket on the premiums, which of course is one of the issues in insuring and funding these with life insurance. Is if one of the parties is not insurable or is super expensive to insure, that might be considered too. And I think all those things can be part of the conversation about what the right formula is.
And
Yeah, I
Mary,
think one of
as you pointed out, Mary, you're probably going to want some sort of deal if somebody becomes incompetent or they want to retire, or, you know, they just got old and want to move down to Florida because they don't like the cold winters in New York or in Nebraska, whatever it is. Don't think that it's only going to be a buyout at death. There may be a buyout or should be a buyout at other times, and maybe they'll put the business up for sale. But as I said, and I have an article about this if anybody wants it, that I wrote with a friend of mine, Mark Pasquale. Life insurance becomes quite inefficient once you reach the age of 80. Keep in mind the following. If you buy a policy of insurance and you die the next day, your beneficiaries are going to get a return of over 10,000%. Now, the average return on the average policy in the United States at normal life expectancy is 6%. Well, if somebody dies early and their family gets 100%, it means those who live beyond normal life expectancy have to get less. And so when you sit down and think about it, that's a problem. In addition, the life insurance is going to be a fixed amount. And most people hope that their business is going to grow in value. So if you say, well, all Marty and I need is to have $2 million on each of us, well, if we have a successful business, it's not going to stay there. So that's another factor you have to consider in the buy-sell agreement. And as much as I love Marty and as much as he loves me, we want our share of the business to go to our families, not to the other shareholder in most circumstances, even if it's brothers, as it was here for the Connelly brothers.
Can I ask you both a quick question that I think is important? Do you feel that the rationale in Connelly would be applied to an insurance LLC? In other words, what happens if I die and the buyout insurance, because it was me, Mary, and Jonathan, so instead of buying 6 policies, we have 3 policies held in an insurance LLC. On my death, does my estate now have to include my 1/3 interest, for example, in this insurance LLC, whatever the values of those policies are? Is that the same concept that Connelly's talking about?
I don't think so,
owns the-
Marty. I mean, if you structure it correctly so that
Who owns
it's
the
not,
insurance LLC?
well,
Isn't it owned
that's
by-
a good question. Maybe it's trust you created, that I created, and Mary's created, or estate. It depends on how it's structured. If on the interest and it's paid, that's not going to be in my estate. It's paid to someone else, then it'll be in my estate. And to control it. For example, I said, and I know you do as well, I say, look, your partner dies and he owns a policy on your life, and his wife or his son or daughter inherits that. Are you going to feel comfortable having someone you don't have a relationship, a policy on your life? What if they turn around and sell it to Don Gotti? How comfortable are you going to feel? So as a consequence, you need to talk through all those things about insurance where someone other than a family member owns insurance on your life.
So, and I'm going to comment on the insurance LLC as well. So I did, in getting ready for this, reread the rulings, and most of them have addressed the incidence of ownership, and properly designed, you're not going to have an incident of ownership. But do you own an interest in the LLC? Because most of them are designed that the ownership of the insurance LLC is going to parallel that of the company that they own, right? And then there's the if you're using term insurance, you have a capital account, and that capital account burns off during the year, and then you have to address that. So I'm kind of inclined to say, Marty, that depending on how it's structured, if you just have basically, you forget the structures, there's a lot of structures out there for the insurance LLC. But if you have a simple structure of an insurance LLC that parallels the company ownership, that insures, holds all the insurance policies, I think there's some I think you've got to give some consideration to the possibility that this analysis could apply. I
The
couldn't
Connelly
conclude when,
analysis.
yes, the Connelly analysis. I couldn't conclude that it absolutely did not. I will admit that I'm a little undecided, but I'm concerned. But the thing is that most insurance LLCs get designed in a way to remove it from the estate. So that's where I'm going back to saying, yeah, but if you just have a simple insurance LLC that parallels ownership, I don't know how Connelly isn't a consideration in that.
I think in that simple insurance LLC, and I've seen them done that way, you have the same issue as you do in the Connelly case, and you have to caution the client about it. If you do a more sophisticated structure where you have trusts or entities own it, so it's outside of everyone's estate, then it's a different ballgame. But I think that is another incentive that we now have to use a more sophisticated approach, because Connelly is a reminder that if you use the simple approach of, if the three of us own the business and the three of us own the LLC all equally, we may have the same issue in the LLC that we did having it in the redemption owned by the corporation.
I think it's something to monitor and consider when structuring the insurance LLC. I don't
Well,
think you
yeah.
can just go
Well,
ahead.
Mary, if you and I each own a third of the LLC, and my third is going to be in my estate when I die, and 2 million, 3 million, whatever it is of insurance is going to come in, I don't think there's any question but that value is going to be in my estate. Now, there may be discounts in valuation, which we've ignored throughout our discussion, which can be important considerations, but absolutely. If you have the shareholders own the insurance through the same mechanism of ownership that they own the company, I think you're back in having the insurance proceeds, maybe subject to a discount, in your estate. That's why when I've done this, I've sometimes had a trust which is out of the estate using annual exclusions or whatever to try to provide the funding. But it's complicated. And keep in mind that of the three of us, Mary, you're the baby and you're a woman. So the insurance on your life is going to be a lot less than on a middle-aged guy like Marty, who's in great health, or an old
Middle-aged.
man like me who has some health problems.
So I'm going to be paying a lot for the insurance on the two of you, right? Is what you're
You
saying?
bet. You bet.
All right. So
I think
I'm
I
going
think a take home message from the comments that Mary and in the conversations with Jonathan are about Connelly and what has to be done, and I think it goes way beyond Connelly. Too often I've seen all these transactions handled in too simplistic of a manner. Mary has emphasized that you need to have a buyout agreement that addresses all the different events that could be relevant, not merely death as addressed in the Connelly case. Mary's talked about hybrid arrangements where you could have a cross purchase to the extent of insurance, perhaps based on an insurance LLC that should be structured more sophisticated to be out of the estate, especially after the reminder from Connelly of estate inclusion. So you really need to think this stuff through. It's not simplistic, and if you handle it too simplistically, it may not work. Mary has talked about how you need to really go through some of the economics so the clients understand what they're doing. We've talked about how you need to have the underlying documentation explicit as to what the clients are intending, because there can be a lot of different results. So
Right.
it really requires a lot of care.
Well, let me say something that won't make any sense to Mary, but Marty, since you've lived in New York and New Jersey, and I live in New York, it will make some sense. Sometimes the owners of the business get divorced, and
No,
their spouse may wind up owning an interest in that business. And all of a sudden, and you might say, no, we're going to provide that the spouse can't get it. Well, guess what? You don't get to decide that. Maybe if you have a prenuptial agreement that's enforceable, but very, very few people have prenuptial agreements or postnuptial agreements. So you need to factor that in. What happens if one of the parties gets divorced and their spouse comes in and winds up owning a piece of the business? What does that do for the buyout? In fact, I've done some where we had an explicit provision in the event of divorce. And sometimes it's even triggered when there is a divorce. And the other spouse, the non-business owner spouse, may wind up getting a piece of that to pay him or her off. But that's something else that needs to be considered, unless you're in Nebraska where people never get divorced.
I think we're kind of getting near the end of time, and we promised everybody, and I think we've already done it, but we've promised everyone some practical takeaways. Maybe Jonathan, you want to provide some summary comments, and then Mary, and then I'll take my 2 minutes and talk about the broader Sorensen's Smaldino issues that I had mentioned early on. Jonathan?
This can be a big area of practice because you're going to wind up representing owners of closely held businesses. They probably never will have thought about it, and you need to get them to think about it and to decide what is best. I mean, there are books written about this kind of stuff, and you need to think about it. Everything from, well, what happens if one of the parties goes bankrupt and a creditor comes in and makes a claim against the business? What if you get divorced? All sorts of, what if someone goes to jail? Do you have to buy them out if they go to jail? And I've actually added that in many of my buy-sell agreements, not because we had OJ as one of the owners, but just because people sometimes do go to jail and people die and people go insane and people get divorced. So you've got to think all that through. I happen to be a fan of the cross purchase agreement in general, but keep in mind, the insurance will become, if you're going to fund it with insurance, it's going to become expensive as the people age. And you may not have enough in the insurance proceeds to affect the buyout because the business is very successful. And the older you get, which means you need more and more insurance as the company grows in value, you're going to need more insurance, and there'll be a limit to how much you can get. And the cost is going to be that much greater because the insureds are older.
And how do you feel about the inclusion of life insurance in the value of the business? You feel Connelly is correct, and that is something that practitioners need to contend with. I'm not trying to put words in your mouth. I just want you to sort of reiterate
Marty, as you know, I think that Connelly is correctly decided. As I said, if you take a look at other things where you have a sinking fund rather than insurance, the sinking fund would be in the value of the business unless you've contracted it away. And whether that will be respected or not, I don't know. But I have no doubt that whatever asset the business owns, whether it's life insurance, whether it's popcorn, whether it's an ostrich farm, whether it's part of the business or not, the IRS is going to insist that that asset owned by the business be considered in determining its fair market value. I don't even think it's arguable.
So let me ask you a question because it's very important for everyone's understanding of Connelly. So based on what you just said, and again, I'm not trying to put words in your mouth, I want you to express what you feel, but based on what you said, had the taxpayers in Connelly adhered to and respected, which they should have done regardless, whatever the result, they still should have respected their document. But had they done a certificate of stated value, had they had a real appraisal done, do you think that would have had any difference necessarily in the result of that the law says that the insurance should be included and you don't get a reduction for the redemption obligation?
Well, Marty, that depends upon whether or not the buy-sell agreement meets the criteria under the 2031 regs and whether 2703 would say we're not going to respect it. I can't answer that question, but I do think that regardless of the asset that's held by the corporation, whether it's actively used in the business, whether it's that vacant piece of land I said, I mean, let me give you one. Law firms in New York and other places began to be concerned about how they were going to buy out partners when they retired or how they were going to buy them out in the event of death. So some of them said, what we're going to do is we're going to buy a building and the firm would rent it back. And that caused a lot of problems, and most of the firms have dropped that because, it is an asset owned by the firm. And then some of the new partners would say, well, why am I paying for this? And some of the old partners would say, I'm not using it anymore. Why should I do it? But, any asset owned by the company, I think, has to be considered. Can the parties contract to say it won't be considered? Sure, but that may not be binding, even if they're not closely related to determine estate tax value.
So then, again, just for clarity, if we had put expressly in the buyout agreement, thou shalt not include insurance unless it passes muster under 2703, that's not going to change the result either.
Well, it's got to, yes, it's got to meet the criteria under 2703, but first it's got to meet the criteria under the regulations under 2031. And there are a lot of cases, dozens, hundreds of cases out there on valuing closely held businesses before 2703 came on the books.
Mary, do you want to make any wrap-up comments on lessons from Connelly, and what are you going to tell your clients? Why don't we do it that way? What are you going to tell your clients? What are you going to do? What should people be doing?
Well, I think the number one thing is that this is an opportunity for all of us to review agreements. I know that every time I touch an agreement, want to improve it. And so this is an opportunity to pull all those agreements together and say, oh, it's kind of a lot of fun because I'm a geek who likes to improve agreements. So it's an opportunity to reach out, connect with your clients on this issue, do review the agreements, get out there on that. I think one of the things that I would say that's really a takeaway from this, and this is something I share with any of the young attorneys that I work with, that if what you have, so, redemption is right sometimes, a cross purchase is right sometimes, a combination thereof is right sometimes. The key thing I would suggest is that there's not one solution for every client. And if you only have one solution, you're going to be replaced by Chat GPT or its successor, artificial intelligence, in short order, right? So where we still have a lot of skill is that we've done this for a lot of people in a lot of different ways. And can you devise the solution that considers the client's objectives, really hear their objectives? I write them down. And what I do with the buy-sell agreements is I actually make a list of each of those triggering events. Jonathan raises the divorce concept. The other is what if one of the partners files bankruptcy? Last thing you want is a trustee involved in your business. So I actually lay out each of the triggering events in a little row and say, what do you want to have happen in each of these events? And then what is the value, and should it be different for each of these events? And do we want to fund these events? And if so, how? So looking at the objectives, looking at and making sure that they do understand the economics of the transaction, and just offering some creative solutions. And we've provided some of those, we've discussed them and put them in the PowerPoint.
So let me conclude with one different point. Jonathan and Mary have said a lot about the Connelly case, and I think we've hopefully given you a lot of practical action steps to take with clients to help them in the wake of Connelly. But I think there's a broader message in Connelly, and we started in December 2020 with the Smaldino case, where again, and that's why I seized on Mary's comment early on that bad facts case. Don't dismiss bad fact cases. There's lessons. In Smaldino, the taxpayers did not adhere to the formalities of anything. Yes, it was a bad step transaction case. Yes, the wife as donee only held the interest theoretically for a day, but they did everything wrong almost imaginable in terms of tax reporting, legal documents, not adhering to the prerequisites in the operating agreement that they themselves created and signed. So Smaldino was a lesson that you have to adhere to formalities. The Levine case, which came out about a year or so ago in the split dollar arena, leaving aside the split dollar, Levine was a taxpayer victory, but the court complimented multiple times the taxpayer and the taxpayer's advisor. They did tax planning with only excess capital, not money the woman needed to live on. They had an independent trustee, an independent institutional trustee. Larson, who was the independent individual trustee, was not even a family member, and he had the sophistication to do the job right. And they adhered to all the formalities in their documents, and they talked about the language in the legal documents that made the case win. And then we had the Sorensen case more recently, the Firehouse sub case. They did a Wandry clause, but they ignored the dollar denomination of the transfer, and consistently everywhere did it wrong. All the corporate records are wrong. When they sold the business, they did it wrong. They talked about specific number of shares of stock rather than a dollar value of shares. The lesson of all three of those cases is repeated yet again in the Connelly case. The clients, the taxpayers here, the Connellys, they didn't fill out their certificates of state of value. We talked about the issue. You need a formula, can't just arbitrarily pick a number. But they didn't even bother doing that. They didn't bother getting the appraisals that were mandated that would have probably met an arm's length transaction requirement under 2703 and may have obviated the case ever happening. They had the brother who was the surviving shareholder, who was the recipient of the shares being bought, who was also the executor in all those roles. Contrast that with what I just said occurred in Levine. We keep seeing reminders of many of the same factors. You need to have proper administration of a plan. You need, or should at least have, independence. You need proper economic analysis, like Mary talked about, like what happened in the Levine case with excess capital. These are the same simple factors that are reminded over and over and over. And the service is not foolish. Their resources, even though they're getting a huge infusion, have been limited, and they have focused on what Jonathan always calls the low-hanging fruit. Why should somebody get into a highly technical argument with a competent practitioner over a technical legal concept if they can find cases where there's so many footfalls in improper administration? So I encourage everybody listening to this, please try to educate your clients on the vital necessity of proper administration. Their planning is not going to work. And I had asked Jonathan some of the questions specifically in our conclusion. I'm not sure Connelly would have been different even if they had done everything pristinely, but they still should have done it. And maybe it would have helped. And frankly, if that pristine administration of their plan included independent appraisals, there may have not been an issue. It may have been a different economic result, but there may not have been an issue. So I think that's a broader take-home lesson for all of us from this. Any final words, or can we wrap up, everybody?
I'm good. Thanks, Marty. Thanks, Jonathan.
Thank you, everybody.
Guys. Thanks
for joining us. Enjoy your July 4th holiday. And before you sign off, Jonathan, if anyone emails you, you will send them the analysis, the article on rates of return on insurance so that they have interesting conversation for July 4th weekend.
Yes, indeed.
Take care, everybody.
But don't try to read it to your children, grandchildren under the age of 18. It's so exciting they won't be able to sleep.
Take care, everybody. Have a great holiday weekend too.
You too. Bye.